Okay, welcome to the Legal Aid of North Carolina Divorce Clinic. While Legal Aid does not offer representation in divorce cases, this presentation will provide you with an overview of divorce law in North Carolina and guidance on how to file a complaint for absolute divorce on your own. The presentation will also address the impact of the COVID-19 emergency on filing for divorce at this time. If you require assistance with separation, support, custody, or complex divorce issues, we urge you to consult with a private attorney before filing for divorce on your own. Our presenter today is Elysia Jones. Elysia is a supervising attorney for the Raleigh office of Legal Aid of North Carolina. She works primarily in the field of family law and domestic violence. She has always had a passion for helping people and enjoys empowering clients and working with the people that legal aid serves. She serves on the WCBA and the NCHA CLE committee. She is on the board of Triangle Area Parenting Support and is a member of her daughter's PTSA. Following the presentation, you will have an opportunity to ask general questions about divorce law. Please keep those questions as general as possible, as we are unable to provide you with legal advice specific to the facts of your case. If you're watching on Zoom, you can ask questions in the Q&A function. And if you're watching on Facebook, you can ask questions in the comments. Thank you for attending today's presentation.
Hi, good afternoon. Welcome to the I hope I can provide some information and guide you through this process. So, legal aid is open and fully operational. Please call our helpline if you need some information on divorce and other services that we provide. You can also check out our website, legalaidnc.org. The court is always updated. The information on court closures and COVID-19 policies. They made a new update today. So masks are mandated and you can check that out on their website as well, which is provided here. So legal aid does not represent you in divorces. This is going to be information about how you can represent yourself. And this is related to North Carolina divorce only. If you need information on divorce in another state, I would consult with an attorney. We have legal aids. There's legal aids across the country that may be able to assist. So let's talk about some points of caution. Entry of a divorce will affect rights of property. So before you think about a divorce, I want you to think about if you have any needs for equitable distribution, which is distribution of property, distribution of assets, alimony, any post-separation support. Post-separation is support that is supplied until alimony is set. So if you have any of those needs, those will have to be done prior to a finalized divorce. If you have custody issues or child support issues, those can still be done after a finalized divorce. So it could be done in conjunction with a divorce, but it won't have any bearing on it. So let's talk about the requirements to get a divorce. The requirements are you or your spouse must have lived in the state of North Carolina for at least 6 months immediately preceding the date you file. So either one. and you or your spouse must have lived separate and apart for 1 year prior to the date of filing. So what the statute actually says is 1 year and 1 day. So it's 366 days that the two of you had to have lived apart. And living apart means under two separate roofs. So the two of you cannot have shared the same household and lived in two different bedrooms and consider that as living separate and apart. Now, how do we proceed? Well, we're going to complete the forms, file the forms, serve the defendant, and then get a judgment. We'll talk about all of that. The forms, these are the scary part and what everyone is concerned about. What you file. So we're going to file a complaint for absolute divorce. So what we consider a divorce in North Carolina is an absolute divorce. Now, there are things called legal separations in North Carolina, which is a divorce from bed and board. We are not covering that in this informational webinar. However, that is what North Carolina considers a separation here. You don't need to have one of those to get divorced. We're going to do a civil summons. A civil summons is a form that serves the other person and lets them know that there's a filing against them. Domestic civil action cover sheet is needed. That's a form that says, this is what I'm filing in court. The Service Member Civil Relief Act affidavit. This is a form that designates whether the defendant is in the military or not. Whether the person is in the military is a requirement, because if the person is in the military, the divorce will not go forward until the person is given a representative, a legal representative, and you would have to put in additional information. I'll go into that later. So there's some counties require additional forms, depending on where you are. There's also optional things such as the indigent waiver form. We will talk about that. What the indigent waiver form is for to waive the fee. The fee for a divorce in North Carolina is $225. The waiver fee will also waive the sheriff fee, which is $30. Then it's the affidavit of indigency, which goes along with the indigent waiver fee. And that's where you would actually go through your finances and the clerk of court will decide whether you qualify to be able to waive that $225. The nccourts.org site has those forms available. Some of your local counties have those forms available for free, and some of them have them available for you to pay. You need to call your county to check to see which one is available. Like Wake County charges, I believe it's $7 for copies of those forms. So make sure you call your clerk's office prior to that if you need that. Some local libraries also have those for free. Our website has forms as well. So let's talk about the complaint. The complaint is what's going to have your basic information. This is a copy of a basic complaint. So you're going to fill in the county, it's going to be the name. The plaintiff is going to be your name. You're going to be the plaintiff in this, the person that's filling out the paperwork. The name of the defendant is going to be your spouse. This is, so you are the plaintiff right here. Your spouse is the defendant right here. You're going to write the last 2 digits of the year, which will be right here. So it would be the file number is going to be for 20, which would be 20, and then it'll be CVV right now. But you don't even have to do that because the court will fill that in right now. So the plaintiff is a citizen, a resident of blank county. What county you're a resident of. So currently I would be a resident of Wake County, and if the defendant was, say, a resident of Durham County, you would write that in there. The plaintiff or the defendant has been a citizen of North Carolina for 6 months. So whoever, it could be you, the plaintiff, or the defendant, or both. So you can fill that in, whichever one applies. Then here's the marriage date. That is important. You need to put that in there. Then the date of separation, that is also important. You need to put that in there. Because as I said, the requirement in North Carolina is to be separated for 1 year. Then you see that right here, since the date of separation stated, the plaintiff and the defendant have lived continuously and separate and apart from each other. No time have they resumed a marital relation and formally existed between them. Now this is interesting because people always ask, well, we thought about getting back together, or we had one time we got back together, does that count? Not necessarily. If you have questions such as that, I think you should contact an attorney because those may not count. At the time of the separation, the plaintiff intended the separation to be permanent. This could also be at the time of the separation, at least one of the parties intended the separation to be permanent. Now here, there were children, there were no children, or the number of children here, then the names, date of birth, place of birth sometimes of the children. The minor children resided with here at. The plaintiff acknowledges that defendant, this is the equitable distribution that we discussed. This is very important. And if you two have assets, so if you two have cars together, if you have bank accounts together, if you have a house together, all of those things have to be taken care of prior to all of this being done. Because once this divorce goes through, you lose those rights to distribute that, or to pull those apart again and to fight over that. And there's many times that people have property or houses together, they want a divorce really quickly, so they go ahead and they get a divorce, and then they're left together dealing with the house and what happens with that. So if you have that situation, it's really important that you contact an attorney to figure out what your legal rights are prior to filing this. Because once this divorce goes through, some of your rights are lost. You can't go back and relitigate something that you've already lost those rights for. So then right here, you're asking for your divorce, and then the plaintiff can, if the plaintiff is a female, or the plaintiff is a male and wants to change their name, can go back to your former name right here, and then you just sign it. Then there'll be a verification form. Now, right now with the COVID, there has been, instead of having it to a requirement to have it notarized, you could have it affirmed. And I'm not sure how long that's going to be for, but at the moment, there's going to be a new requirement where instead of it having the, this is verified, it could just be saying a notification that this is true. So this is the verification right here with the notary, but because of COVID, they're waiving some of this and saying that you can affirm that this is true. Now, as far as how long that's going to be, I'm not sure. The domestic civil action sheet, this is what the domestic civil action sheet looks like. So here, You're going to put your county right here, the name of the plaintiff, the person that's filing, that would be you, your address right here, the defendant. You have to find out what the defendant's address is. A lot of times people can't find the defendant's address, or you don't know what it is. That's going to be difficult because one of the things that you need to know is where the other person lives so the other party can be served. If you can't serve them, then there's going to be, you're going to have to request from the court permission to serve them by publication or some other means. And then you would put their information right here. Summons submitted, yes, right here. All plaintiffs are only party listed right here. Then complaint, you're gonna check right here. You're gonna put the date right here. You're going to put initial filing, jury demanded and pleaded. No, there are no juries in a regular divorce. Your name is gonna go right here, your name and address again. Your telephone number right here, your email address, initial appearance. Then you're going to request for a divorce. There are other things, if you have those equitable distribution or any of that other stuff, then some of the things would be checked. But again, if those are some issues that you have, please consult an attorney. And then make sure you sign right here. Okay. So this is the civil summons form. Again, the civil summons form is the form that lets the other party know that you are serving them with a complaint or a motion or something for the court. And it's almost similar to what we just filled out. So it's going to be district court. Divorces are always going to be in district court. The county is whatever county you live in. Again, you are the plaintiff, your address right here versus the defendant. And right here, defendant's name goes in here. And then the defendant's name and address goes in right here. Then right here, your name goes in here. You don't fill anything else out. So the defendant has 30 days after service to file an answer. In most divorce actions, defendants don't file an answer is not required in a divorce. The Service Members Civil Relief Act, let's talk about this. So under North Carolina state law, what you would do here is you would write the county again, name and plaintiff. A lot of these are going to be the same information over and over again. The plaintiff's information, defendant's information, so your name and address, the other party's name and address. So here is, I have personal knowledge, or you don't have personal knowledge. So if it's a recent breakup, so if it's just past that year, many times you have personal knowledge. So you can put that I have personal knowledge, and then right here in number 2, you're going, in this blank space, you're going to write down how you know. So this is my current spouse. This is how I know that the person is either in the military or not in the military. If you don't, so sometimes people haven't gotten a divorce for many reasons. Finances, or they just didn't get around to it. They stayed on the other party's insurance, all kind of different reasons. They were married and wanted to stay together for the children, so they just separated. And you don't know where the other party is now. You don't know if they're in the military. So there's this website right here, and you would check that website to see if they were in the military. You put in their information, their social security number, their birthday. It pulls it from that date, and then it'll print out a report. You attach that report to this. And this is also notarized right here, as you can see. But this may have the exception as well with the affirmation. So you would put this in, date, sign, all of that. But for the ones that are more recent, you could put in the information how you know, or if you know that the person works at, say the person works at Lowe's, I would put that I know the person isn't in the military because the person has a full-time job at Lowe's. Then you would put that in there and you wouldn't have to pull the website. So let's talk about the petition to sue as an indigent. So this is so that you would not have to pay that $225. $225 is a lot of money. Again, this is in district court. Divorces are done in district court. The county that you're in, your name, you are the plaintiff, the defendant's name is your spouse. So petition to sue right here for claims and petition to file motion. Now, if you receive any of these, if you receive food stamps, if you receive or any kind of benefits, SSI, SSDI, temporary assistance, any of those paperwork, bring that paperwork with you to the court, show them proof of that, and that would help you. If you are represented by legal aid, they can fill it out right here, sign it, and give it to you. And that would also waive it because it'll show our requirements. But you would also fill all of this out. Then if not, if any of these don't apply, then we will talk about the additional paperwork that would go with. This is the additional paperwork that goes along with that. So if none of the other things apply to you, so if you don't receive any kind of governmental assistance, so the reason that if you receive the governmental assistance or you are a recipient of one of legal aids or maybe PISCA legal services, if you receive any of those services, you would qualify under that term, then you've already been pre-qualified. But if not, then you would fill out this information right here and the clerk of court would decide whether you would meet the requirements to do the waiver of the fees. If you are granted that, then that would waive the $225 of the fees. It would also waive any additional fees. So the additional fees for a divorce, a hearing is an additional $20 fee for any in-person hearings. It also waives the $30 sheriff fee. So some of the counties, this is one for Wake County. This is a notice of a divorce hearing. Durham has a different forms. Cumberland County has different forms. Different counties have different forms. So you would fill this out. And if you see that this is, this says that different counties have different forms. So this is important to note. In Wake County, whether you are an attorney or you have an attorney or not, that was important because in Wake County, divorces are only on Fridays and divorces by attorneys were at 9 o'clock and divorces pro se, which is where you represent yourself. A pro se litigant is a person that represents themselves. those start at 10:30. That's why this says I have an attorney or I don't have an attorney. That's important to note, and different counties have different requirements. So notice in the forms and making sure that you put correct information is important, or that my spouse has an attorney is important as well, because they will set it at the time that's appropriate for your case, the date that's required. Like in Wake County, it'll be 41 days after the date that you filed. Do you need an interpreter? Yes or no? What language? That's important because that needs to be done in advance so that you're being able to get an interpreter. Interpreters are provided by the court for you. Does your spouse need an interpreter? You need to put that down as well, because your spouse has the right to have an interpreter if your spouse needs an interpreter. Okay. Is this for trial or summary judgment? Are you going to argue about anything or not? So this is for remote summary judgment. So right now, our divorces are by remote hearing. So we're having WebEx divorces. Or are they having a trial if it has issues such as alimony or something else that's going on? So the filing. So you're now ready to file. So the complaint. This should be 3 copies. You only need 3 copies of everything. You would have 3 copies of the complaint, the domestic civil action cover sheet, the civil summons. Some counties require different things, and some counties require different colors for things. The Servicemen Civil Relief Act. There are certain additional forms that other counties require, such as the calendar request form. Wake County also has like a notice of hearing that's just specifically for divorce, and the petition to proceed as an indigent. Depending on which clerk you're in front of, depends on whether you need 1 or 2 copies. I always say make sure that you have more than 1 if you're going to do that, because you want to make sure that you have 1 for the sheriff, because you need to bring 1 to the sheriff if you're granted it, so that the sheriff can see that you have that to be able to waive that fee. But that has to be signed by the clerk of court. So if you have 1, make sure that the clerk gives you a copy of the one that they've signed. Okay. And make sure that you have copies before you go to the court, because the court will not make copies for you. And if they do make copies, they will charge you for copies. So filing, make sure that you have the necessary copies. Everything is either affirmed or notarized. Everything is taken care of. Everything is signed, dated, and put in order, handed nice and neatly before you go to the clerk's office. Whatever they need, they'll take the original copies. They'll hand you back 2 copies of everything. 1 copy is for the sheriff to be served. 1 copy is for you. Service. So there are several ways to serve. All right. 1 is by sheriff. Now, if you're doing the agency waiver fee and you know the defendant's address, the sheriff is the way to do it, because then you don't have to pay that. You don't have to worry about anything. The sheriff will try to attempt to serve the person and then give notice back to the court that the person was served. Certified mail. So if you do certified mail, you have to serve the person with the certified mail, and then you have to tell the court, you have to do a notice of publication to show that you served the person, and that you have to show the green card back to the court and bring that back prior to you being able to schedule a divorce. Now, publication, there are many times that you don't know where the person is. You have to attempt service by sheriff or certified mail first. That has to come back. Then you can attempt for publication. You attempt publication in the address for the last place that you know the person was. You have to have proof that you've attempted that. So when you do publication, the newspaper will send you a notice of affidavit saying that they've run the ad where the legal ad where the person was, and that has to run. It's a 3-week ad, so it'll run continuously for 3 weeks. Now that can be expensive depending on where you have run it. It can run, I've seen it run anywhere from $144 to $700, and it really depends on where the person's located. So the sheriff, you would hand them 1 copy of the complaint and 2 of the civil summons. What they do with the summons is they hand 1 to the defendant, and they will take 1 back to the court that shows that the person was served. There's a $30 fee for them unless it's waived. You make sure that you hand them a copy of that indigent waiver to show that you do not have to pay that fee if that's approved. If you do it by sheriff and the person was served, you can always call to the sheriff to make sure that the person was served by calling their civil summons number. They would give you a piece of paper with the number on it, and you can tell them your file number. They will tell you what date the person was served, and if the person was served, what date the person was served, to verify service. And that's all you would need to know. Certified mail is, as we talked about, is that green card will have to come back to you. You have to keep that. You have to turn that back into the court. Then you have to do a notice back to the court of a publication, is what it's called, a paper, saying that you served the person to a certain address, the address that you served them, and it was verified. However, with the COVID cases, that may be an affirmation, I'm sorry. So you may just be able to affirm that you had served them at that address. Here it is that we were just talking about. Affidavit of return of service by certified mail. And this right here, you see that it's notarized. However, because of the COVID cases, some of those notaries have been replaced by affirmations. So that may be replaced by an affirmation saying that I affirm that I did this, as I said. But you have to also attach that green card. That green card has to have a signature on there. And you would put in the information of where you signed it, where you sent it, the county, your name again, plaintiff, the defendant's name. The file number goes here. So the file number you will have by now, and right now, if you filed it, say yesterday, it would be 20 CVD XYZ, whatever number that the court assigned you, you would go ahead and put right here. Then you would sign it, and you would put your information right here, plaintiff signature, print your name, address, telephone number. Now, if you are able to get it notarized, please get it notarized. Acceptance of service. There are times that the defendant wants the divorce just as much as you want the divorce. These are provided by the court. You are able to do that. You can hand them one of these acceptance of services. I will tell you that this has to be filed with the court after the divorce is filed. So you can't file an acceptance of service at the same time you are filing a divorce. So you can go ahead and file the divorce, and the defendant can fill this out, acceptance of service, and then send it back to the court the next day. or can file it a few hours after. But they actually have to be served with the divorce. There has to be a divorce filing before there can be acceptance of service. But this is just saying that the person submits to the jurisdiction of the court and is agreeing to the divorce. Not necessarily agreeing to the divorce, but is agreeing to the service of it. Publication. This is the means of last resort because it is quite expensive. As we've discussed, you have to do sheriff or certified mail. There are several things that you have to do, and Wake County, some of the other counties have an affidavit of due diligence is what it's called, where you have to show all of the steps that you took prior to doing a publication. So internet search, DMV search, sometimes private investigators, contacting family and friends, contacting whoever you knew before, any places that you knew the person was, contacting last jobs, trying your best to serve the person prior to doing publications. Now, entry of judgment. Ways to have the divorce entered. So an entry of judgment before the clerk, that is in some counties allow that, other counties do not. Uncontested divorce before the judge, meaning that you're not arguing about the divorce. The procedure for entry of an absolute divorce may vary from county to county, which is absolutely true. There are family court rules. Some counties have family courts, some do not. Some have specific rules, like, as I said, Wake County is a Friday only divorces. Some counties have different rules. So a clerk divorce, you have to wait 30 days from the date a defendant was served. On that day 31, you can go to the clerk's office. There's a special judgment for absolute divorce before the clerk. It's a different form. You fill that out. The clerk can only do a simple divorce. So if there are other pending actions, so if you had an equitable distribution case, you had alimony, if you were asking for anything besides a divorce or the resumption of a maiden name, then the clerk cannot do that. Then there's the certificate of absolute divorce or annulment, which needs to be done. That's the form that is sent to North Carolina Vital Records in Raleigh. This form, it's a certain requirement, and it can only be that requirement. It has to be cut off by the dotted lines. You will need 3 copies of each document, except for the Vital Records form. It only needs 1 copy. So here's the judgment for absolute divorce before the clerk. I do this often for clients. This one is simple for counties that allow that. Some counties have special requirements, such as you are a resident of that county or one party is a resident of that county. So this right here, what county it's in, the plaintiff again, here, so you would write your name, the defendant's name right here. So the findings of fact. So the defendant was properly served. So that's going to be important. The person has to be served with it. So you can't do this without service. Now, the person either failed to make an appearance, so the 30 days has passed and there's been nothing that you haven't received anything back besides either a green card or the person, you received notice from the sheriff that the person was served, admitted all the plaintiff's allegations. So they wrote an answer and said they admitted it. They filed that waiver, which is what we've talked about previously that you saw. They sent something to the clerk saying that they're waiving their right to answer. So if they file that, then you can fill in one of those right here. Defendant is not an infant or incompetent. So if the person is an infant or incompetent, you cannot do this. the defendant was served with notice of hearing as required by the rules. If the person has filed one, if one of these applies, then the person doesn't have, then this is not required. But if the person failed to do this, so if the person filed an answer, then you need to send them notice of this. The person was not served with this because they failed to make an answer. So if they never sent you any notice or anything, then you don't have to send them notice of this. You just send this to the courts. Then you would put, one of you usually has to be a resident of the county that you're requesting this in. Then you would put that you were married, the date you were married, then you were living apart, and one of you had the intent to be separate. Now this is if the person requests the name. That's all you would fill out on this form. And again, we talked about all of these. The clerk fills out the order. So this is their certificate of absolute divorce or annulment. So right here's the file number. You will have the file number because it will be stamped on the paperwork that you received back when you filed it, your county. So you are either husband or wife, your first name, your middle name, your last name, your state, your county. So if the other party lives in North Carolina, you didn't have to have lived in North Carolina to be able to file in North Carolina. And so where the other party lives, right here, the date of the marriage, the place of the marriage, number of minor children, date of separation. That's all you need to put in. After printing this, you need to make sure that you cut this right here. So the clerk divorce, once you fill that out, you give it to the clerk and leave it with a self-addressed stamped envelope, and they'll send everything back to you. So you wait the 30 days out. You'll need all of this information, notice of hearing, certificate of service. Important, you need to make sure that you check with your clerk in your county on the specific rules. Each county has specific rules on how they do divorces, specific days, specific forms, and how they want everything. But they usually tell you up front, or they have a packet that they'll give you. The notice of hearing, so they either have it on certain days of the month or certain days of the week. Now, if you had to have a live divorce, make sure that you have the judgment, certificate of absolute divorce, a stamped envelope with your defendant's address on it, judgment of absolute divorce, again, certificate of absolute divorce or annulment, and you'll need to fill those out by the computer or print copies. Some counties have them and will provide them to you if you don't have copies of them. Like Wake County will provide them if you don't have copies of them. Here is a judgment for absolute divorce. So you would fill in the county right here. You fill in the plaintiff's name, that would be you, defendant. The file number, again, you would have found that and have that, so you fill that in again. So pursuant to the local rules of wherever you are, the plaintiff is a resident of what county you're in. Defendant is a resident of wherever county you're in. The person was properly served by one of those means. The plaintiff and the defendant were married on right here, the date. You live separate and apart from more than 1 year. Now, this is if you decided to request the resumption of your maiden name. You put that right here. There were children or no children, you would put that information right here. Then this is already there. So you don't fill anything for here because this is what the court would conclude. So you would just check if you're asking for your maiden name back, date it, then the court signs. Their certificate of service is saying that you're giving this copy to the other party if the other party isn't there in court with you. Then you sign and put your name right here. Okay. I think, sorry, after the hearing, okay. Well, after the hearing, you're supposed to, the judge will determine if your divorce is granted with the testimony and the pleading, or the clerk will decide whether it's granted. They will give you notice, they'll make copies, they'll send it to you. They'll send you notice that if your name can be changed, and they'll send you that form as well. They'll give you a certified copy. You only get one certified copy, usually. Sometimes you'll get two, depending, but most of the clerks only give you one. That's going to be the raised certificate. Most of the courts will charge you $10 for a new one. That's what you're going to need if you requested a name change, to take that to the Social Security office. Now, with the COVID-19 in the courts, some of the courts are closed or the hours are changed. You may need to make sure that you contact your clerk's office, your local court's office, just to make sure what they're doing, how they're operating. Some are doing virtual divorces. You want to make sure that you may be filing them online or mailing them in. You want to see what the procedure is because of COVID. You should make sure that you are not entering the court if any of these have proceeded to you. You've traveled internationally, you have a fever, you are wearing a mask, you've been told to self-quarantine, you have a known exposure, you've been diagnosed with COVID, you reside anywhere near anyone that has COVID. Make sure you are socially distancing, that you have face covering. Thank you so much for attending today's divorce clinic. I'm ready for questions.
All right, so if you are watching on Zoom, please use the Q&A function to ask your question. And if you're watching on Facebook, you can ask your questions in the comments. We do have a couple questions right now. So the first one, this person said they were on the website looking and they asked, would we use the judgment for absolute divorce before the clerk?
So you would use the judgment for absolute divorce only in a county that does clerk's divorces. And I would contact your county to see if they accept clerk's divorces.
Okay. Next question is it mandatory to give my spouse my home address?
So that depends. If you are covered under the address confidentiality program, then no. If you are using a PO box and you're using that, then no. Otherwise, you have to put your address on there. If you are using the services of an attorney, sometimes the attorney will use their address.
Okay. Next question is, how long would it be after divorce that I can be remarried?
You can get married the same day.
Okay. Cool. That's all the questions in the Q&A. I'm just going to give them a little bit more time to see if anybody's writing. On Facebook, we don't have any questions, but I did put there was a question about how to get the documents. So I put in the comments about the link on our website to get the divorce packet. And if you're watching on Zoom and you registered with your email address, you'll be getting an email after this with the link to that packet as well. Yeah, it doesn't look like we have any more questions. So thank you so much.
Thank you. Have a good afternoon, everyone.